Ladies and gentlemen, thank you for standing by and welcome to the BIA Knowledge Leadership webinar. During the presentation, all participants will be in a listen-only mode. If you would like to ask a question during the presentation, please use the chat feature located in the lower left-hand corner of your screen. If you need to reach an operator at any time, please press *0. As a reminder, this webinar is being recorded today, Thursday, March 19, 2015. I would now like to turn the webinar over to Robin Thompson. You may begin, ma'am.
Thank you, France. On behalf of the team at BIA, welcome to our March webinar, where our guest speakers, John Isaza and Tom Reding, will be talking about how the changes to the Federal Rules of Civil Procedure will affect information governance. As France reminded you, please send your questions through the chat window, and those we don't get to during the program, we'll get to at the end of the program. BIA began producing this educational series in June of 2012, and we plan our curriculum of courses based on what you most want to learn about. To that end, there'll be a short survey as you exit today's program. Please take a second and complete the survey and let us know how we did today, and let us know what types of programs you'd like to hear in the future. Now it is my privilege to introduce today's speakers, John Isaza and Tom Reding. John is a licensed attorney, leading author, and speaker on information governance and records management issues. He is a distinguished member of the Company of Fellows of ARMA International and the recipient of the Brit Literary Award. In addition to being CEO of Information Governance Solutions, John chairs the Records and Information Governance practice at Ramon PC, a global law firm. Tom is a recognized authority and thought leader on knowledge, content, document and records management, data governance, litigation support and privacy, and has the distinction of being a certified records manager. Tom frequently consults with organizations to help them with regulatory compliance, litigation support, and privacy. It is my distinct pleasure to turn the program over to John Isaza.
Thank you. Thank you for having us. And at this point, I see that the slide has already been put up, sort of ruining a little bit of the punchline here. So the computer says I need to upgrade my brain to be compatible with its new software. Anyway, so there are days I honestly feel that way, where I feel like my brain is not keeping up with it. And so obviously, speaking of catching up, the Federal Rules of Civil Procedure are also trying to catch up, and so they're looking for an upgrade as well. So what I'd like to do now is proceed to talk to you a little bit about our agenda for today. And I'm going to start by giving you a procedural history of how the rules have come about and where they are going to be by December of 2015. Then we're going to give you an overview of those proposed changes, concluding with how those changes will affect eDiscovery, IG, and RIM practices. I have to tell you, though, that at the outset, that don't expect there to be anything earth-shattering from this presentation or from the revisions to the Federal Rules of Civil Procedure. What you should expect are very subtle changes that are poised to make some big changes in how information governance is practiced. And so you're going to see a lot of emphasis on routine good faith business practices. And really, I think that's going to be the bottom line. So with that being said, I think you can probably leave now. Just kidding. So let's start with that procedural history. Back in, even before December of 2006, when the Rules of Civil Procedure were originally revised, they had been circulating for a couple of years before that, and it was a big sea change in the way things were approached when it came to discovery. Up to that point, it was never really certain whether electronically stored information was officially going to be admissible. You had to jump a lot of hoops to get electronically stored information admitted in court. There was a lot of debate about emails and so on and so forth. And in December of 2006, that made it official that everything that's electronically stored is subject to discovery if it's relevant to the subject matter of the action. So as we progressed with the changes in 2006, by May of 2010, so 4 years later, the Duke Conference began to discover or began to broach the issue of some discovery abuses that were taking place, some disconnect that was taking place from court to court, from state to state, a lot of ambiguity, a lot of uncertainty, a lot of over-preservation. And so fast forward during the last couple of years, and there has now been a concerted effort to try to rein in the amount of data that's going to be subject to discovery and try to maybe put more rules, not so much in how to rein in the data itself, but actually reining in the courts on what they can do to punish you in the event that you fail to preserve something. And we're going to talk about that in a little more detail. So where we are right now, as of September of 2014, the Judicial Conference has approved the revisions. They have been sent to the Supreme Court. And sometime this year, probably before the Supreme Court adjourns in June, they will officially ratify the proposed revisions. There's really been no indication that they will not ratify them. Congress will then approve them, and the earliest implementation will be December 1 of 2015. So that's really when you need to be planned to have everything lined up and ready. Tom put this slide up. You call it lying, I call it perfecting the truth. I guess it's some sort of a slide on us lawyers out here, but I'm not going to take any personal offense to it, Tom.
Thank you, John.
You're welcome. So let me proceed now to an overview of the proposed changes. So there are three big intended advancements with the revisions to the Federal Rules of Civil Procedure, and one of them is to advance early case management. So what was a tight time frame before will actually become even tighter now under the proposed revisions. In addition to that, there are amendments that are focusing more intently on this concept of proportionality and exactly what needs to be taken into consideration when you consider what one side needs to produce, and when you make a decision as to whether or not you need to preserve something or produce something, whether or not it really is proportional to that case. And then finally, the rules regarding the preservation and the sanctions for spoliation, and this is really more of a control on the courts that's being imposed on what could be considered sanctionable, not so much what could be considered sanctionable, but what type of punishment they're going to issue for failure to preserve information. So beginning with Rule 1, just and speedy justice, and it says here that, this is obviously the very first rule of the Rules of Civil Procedure, and that is that the rules should be construed, administered, and employed by the court and the parties, and notice I'm highlighting and the parties, to secure the just, speedy, and inexpensive determination of every action and proceeding. Believe it or not, prior to this what appears to be a very subtle revision, it was only the courts that were tasked with trying to administer just and speedy justice. And now the parties, which means the plaintiff, the defendant, the attorneys, are being tasked with ensuring that this happens. So this rule is going to be, I think, a fountain of future decisions for possible sanctions or for courts to find that you're being obstructive or that you're not cooperating in discovery. So bottom line is that the judges are not the only ones that will be tasked with speedy justice, but lawyers and parties will also be tasked with it. So that's an important consideration. As I mentioned earlier, the timeframes are going to be a lot tighter. What used to be 120 days to serve your complaint has now been reduced to 90 days, and that creates a domino effect down into when the scheduling order meeting takes place. So basically 60 days after a defendant has appeared in a case, that's when you go in for this scheduling order. And that scheduling order is an important order because that's when you go in to decide how it is that when information is going to be produced. And so you really essentially need to be ready within 60 days after you appear. You need to be ready to start to tell the court when it is that you're going to be producing the information, and you darn well be ready to produce it if the court requests it. Under Rule 26D1, there's also going to be some requests that you will need to be responding to as the case begins to progress. So these requests will come in earlier, fast, and furious. So again, you need to be prepared from an eDiscovery preparedness point of view. So bottom line, tighter timeframes means that you need to have all your eDiscovery ducks in order and early in the process. Rule 34 will focus on amendments to promote proportionality in discovery. And that's where I was telling you that now this is where the courts are going to have more discretion in determining a very defined set of rules around whether or not something is proportional. And so if you are a defendant or a party really trying to object to something, you can't just object to it as being unduly burdensome. You have to specify with specificity, and notice I put with specificity in quotes there. It needs to be with specificity so that the court can make a decision, as we're going to see in the next slide, as to the different considerations as to whether or not something is proportionate. So is it really going to be something that's going to cost you so much money to produce? So if you're going to do that, the more specific you are, you might want to maybe give a rough estimate saying we estimate it's going to cost us $3 million to come up with an index for a bunch of legacy tapes. The case is only worth $50,000. That's where proportionality starts to come into play. So if you're responding, you need to state that you're going to produce copies of the documents instead of permitting an inspection. So if you're not going to permit an inspection of your systems, then you need to state how you're going to be producing the copies and the time frame for when you're going to be producing them. Again, as you're looking at those time frames after the scheduling order begins, when the scheduling order is going to be set, those 60 days, then you need to really be prepared well in advance. So all the more reason why you need to have a solid information governance program that includes legal holds. So I promised you that I would give you the terms of what's going to be considered under proportionality, and here they are highlighted in red. And so what we need to consider as we determine whether something is proportional in terms of the effect that discovery will have on you will be the needs of the case, including the importance of the issues that are at stake, the amount in controversy, like the $50,000 example that I gave you versus $3 million, the party's relative access to relevant information, your own resources, which means that if you're a deeper pocket organization, you need to be a little bit more resourceful. The importance of the discovery in resolving the issues, and whether or not the burden or expense of the proposed discovery outweighs its likely benefit. So again, you can start to think for yourself of some examples where what's being requested is so ridiculously out of line from what's at stake in the lawsuit that you can see now that the courts are being very clear direction and the parties are being very clear direction in making the decision. So one thing to point out, as has always been the case, just because something is discoverable doesn't mean that it has to be admissible in court. So that rule has not changed. But interestingly enough, one of the big changes that's occurring under Rule 26B1 is that discovery is limited on the basis of both relevance and proportionality. That's simply how it's phrased. Those of us that grew up being trial lawyers in the 90s and early 2000s have always been used to the phrase the right to request information that's relevant to reasonably calculated to lead to the discovery of admissible evidence. Okay, that phrase is going to be gone. So there will no longer be sort of that gray area of what's considered reasonably calculated to lead to the discovery of admissible evidence. I remember in my days when I used to go to depositions, there would be all kinds of fishing expeditions by relying on this phrase reasonably calculated to lead to the discovery of admissible evidence. It was a very broad standard for discovery and really was wrought with discovery abuses, and it's really heartening to see that the proponents of these rules have really focused on that very troublesome provision that has been misinterpreted at the court level as well. That's a big change, by the way. And then finally, speaking of big changes, Rule 37E is really the one that's intended to have the biggest impact here, which is, as I mentioned earlier, a way to rein in the courts in the types of sanctions. And what was happening in the old days, or at least in the present state, is that the courts were finding exceptional circumstances left and right for what they considered to be things that were not routine good faith operations. So what was happening is that if you were negligent in not producing something, the court was then saying that was an exceptional circumstance and the ultimate sanctions could be issued to you even if you were negligent. So for several years now, the courts have really blurred the line between the fault or the punishment that's given to you for something that's happening as a result of an accident versus something that you did with a true intent to hide the information. And so now the rules are focusing on that intent. So here's again, this slide repeats the current language, but this next slide then tells you what the rule is going to say, and this is where it really gets interesting. So here it says that if you fail to preserve ESI that should have been preserved in anticipation or conduct of litigation, and it was lost because you fail to take reasonable steps to preserve it, okay, and somehow or other it can't be restored, then you can, the court may, if it finds that there was some sort of prejudice to the other side. So first it needs to find that the other side was harmed by it. They can't just sanction you because you lost it, okay? There needs to be sort of a finding of prejudice. Then the court can order a punishment that's no greater than necessary to cure the prejudice. So it could be something that, it could be a sanction, something like says, okay, well, the other side had to incur some attorney expenses, a couple of $1,000s in attorney expenses. Maybe the punishment will be that the other side pays for the attorney's fees in kind of trying to find the information or trying to discover the information, but really nothing that's going to be earth-shattering or dispositive of a case. So again, that's if they find that there was a finding of prejudice. So you have to have that finding of prejudice. On the other hand, if you fail to take reasonable steps to preserve it and the court finds that you intentionally, okay, deprive the other party of the information, then that's when the court can really bring in the big guns. They can presume that the lost information was unfavorable to the party. They can instruct the jury that it may or must presume that the information was unfavorable to you. These are the adverse inference instructions. And the court can go as far as to dismiss the action or enter a default judgment against you. But the key here is this focus on intent. Now, Judge Scheindlin and other critics of this provision are very concerned that this is going to really open up a lot of discovery abuses. But frankly, having been on the committee that proposed revisions to these things, we looked at many different iterations of this, and this is really kind of a compromise. So very important change going on there. So what's the summary of these key revisions? Rule 37E application for failure to preserve ESI is now being revised. So factors have been removed for the courts to consider when assessing whether a party's failure to preserve was willful or in bad faith. So basically, the court now has to essentially find that intent in making the determination of whether or not it's going to give you some very serious sanctions. You can't do serious sanctions simply because there's mere negligence or even gross negligence. There has to be that finding of intent. In criminal law, it's called mens rea, that mindful intent to destroy something. So I think that really will open up a little bit of ease on our part if you're a defendant or if you're a large corporation trying to produce information in discovery. You can take a little bit of breath and saying, okay, as long as my systems are in place, I'm going to trust that my systems will work, and if God forbid something happens, I know it's not going to be the end of the earth because my systems were created with a routine, good faith business purpose, and it's just a matter of the system having failed, as opposed to the court simply inferring some sort of intent without proving it. So we rarely back up our data. We prefer not to keep a permanent record for everything that goes wrong around here. Speaking of which. So now we'll go on to the effect on eDiscovery, RIM, and IG practices, and I'll be able to shut up for a while, and we'll let Tom take it from here.
Thanks, John. And during your first part of the presentation, I was writing down a few things, and I'd like your opinion on them because I'm going to do a little role playing right now. I'm the information governance officer in my corporation, and you're my corporate counsel, so I'm seeking your advice and counsel on a couple of matters that I picked up from what you said. Proportionality, might that be impacted whether or not we have a good information governance program in place and are routinely applying our retention rules and disposing of information routinely? Might that be taken into consideration when proportionality is determined?
Yeah, I think that everything is up for grabs when considering proportionality. So I would hate for anybody to think that if you have a solid information governance program that the court is somehow going to lean harder on you because you have everything lined up. I don't think that's what they're intended for in proportionality. Proportionality is really more intended, very case specific. The considerations that are very case specific. So I really would hope that the courts are not going to sit there and somehow punish you for being efficient in your systems. Okay. I'm hoping that you'll be able to make the distinction from case to case.
Very good. Okay, I'll probably ask you some more legal advice as we proceed here. So let's go ahead and continue on. So this is a perspective view of eDiscovery monopoly today. And what we're going to put over in the left-hand corner on this new version of eDiscovery Monopoly is good information governance practices and an ongoing program in your organization so that you're better able to respond in the future as discovery may come your way.
So the bottom line with all of this is that the amendments are intended to bring focus on litigation back to where it should be. And I'm quoting this Mark Golich because I really think he put it very nicely or succinctly. On the merits of the claims and defenses rather than on discovery sideshows or unfair leverage due to the sheer costs and burdens of unrestricted discovery. So I think that's really what the revisions are intended to capture. So with that said, let's look at some high-level practical effects from these revisions to the rules of civil procedure. And one of them is that we will now have finally what I think will be a uniform standard for spoliation, focusing back on that 37E, that distinction between the courts will now say, okay, did it rise to the level of intent? If it rose to the level of intent, wow, we're going to issue these really terrible sanctions. But if it was just a mistake, that's negligent or even grossly negligent, let me, the court, give you some sort of a sanction that's relevant to or relative to the prejudice that the other side suffered. It will be very interesting to see how the courts wind up navigating those waters.
So, John, let me ask you. John, let me ask you a question.
Sure.
Back to my earlier one. If I have not made a responsible business decision as a corporation to set up a records and information management, information governance program, might that be viewed as irresponsible and therefore potentially subject to a spoliation decree?
Absolutely. Absolutely. In fact, oh goodness, I quote this often in my papers. There's a white paper written by, oh gosh, I want to say Facciola or one of those federal judges, federal retired magistrates, and he says he wrote a whole paper for ARMA. If you're interested in it, I'll be happy to give you the quote afterwards. It's just not off the top of my head. But he basically says that failure to follow the generally accepted record-keeping principles is tantamount to gross negligence. And he says that point blank in his white paper. It's never been said in a decision, but he says that in his white paper, which I think should be given some credence. Could
that be Judge Ron Hedges, John?
That's it. It's Judge Hedges. Yeah, I have the paper, but I forgot which was. It was one of those judges. Yeah, it was Judge Hedges.
Very good. I'm sorry to interrupt you. Please continue. I'm just trying to reiterate to our audience the importance of where we're going with this.
Sure. So as I mentioned earlier, the other high-level practical effect is the attempt to curb those fishing expeditions by really removing that phrase, reasonably calculated to lead to the discovery of admissible evidence, and really focusing only on relevance and proportionality. So that's another big takeaway from these revisions. And then the other takeaway is that now the lawyers and the parties are expected to participate in this just and speedy justice and according to Rule 1. And I really am very curious to see how the courts are going to run with this in trying to, again, curb those fishing expeditions, curb the overbroad request for discovery. So I'm hoping that the combination between Rule 1 and the proportionality under Rule 26 requirements will now allow the courts to really help rein in the sort of the overbroad discovery that's out there. And so the final thing, and what we'll be focusing on in the next few slides, will be the 4 keys that we'll take away from this, which is that there are reasonable steps that are key to the defense of spoliation, that early preparation is key for eDiscovery, that the records retention schedule is key in the defense of spoliation, and we'll be elaborating on that later on, and that intent is a key to finding a spoliation and hard sanctions. So with respect to that first one, yeah, go ahead, Tom.
As John has said numerous times already today, that it's very important to make sure that your information governance and records and information management program is closely linked to your legal hold system, your preservation system, and corporate counsel. It's also very important to follow those 7 important steps to legal holds. That's something that you can get from John's website at informationgovernancesolutions.com or infogovsolutions.com. Also, this prediction that John was referring to, that Judge Shinlin and others have, that expect that there's going to be some litigation over the whole aspect of what's reasonable steps to preserve, especially with regard to electronic information. These are going to be more and more challenged, and once again, the importance of information governance and a good retention program is key to this whole thing. And then one of the other reasonable steps is, of course, the best practices around policies and procedures, making sure that those are in place that describe your overall information governance and records management program. The other, some other recommended information governance actions that we're encouraging people to do is, if you haven't already done so, do a self-assessment of your program. ARMA International has some excellent tools available on their website that you can leverage and take advantage of, as well as others out there if you're using third-party consultants, such as John and his organization. The ability to identify and prioritize the gaps in your information governance program. As somebody who's been a practitioner in this space for many, many years, each and every organization I've walked into, I've been able to find gaps in our program. So identifying them and prioritizing them is going to be key. Also, as we all know, that executive champion for you for your information governance initiatives. Recently, I had a chance to talk to a longtime professional friend of mine who's in the Houston area in the oil and gas space, and she told me that she never imagined herself working for somebody like this, but the person turned out to be their executive vice president for operations. But he was the #1 change agent in their organization, and that couldn't be a better place for her as somebody who's new to the organization and setting up an information governance program from day one. Also, some things to include in your self-assessment. You must be very specific and ensuring that you understand what's asked of you in a preservation notice, in an order from the court, and also when you're requesting information from the opposition. Those things couldn't be more apparent because, as John stated earlier, there used to be fishing expeditions, or there was the time that I remember sitting and talking to general counsel and said, we'll just fill up an 18-wheeler full of record storage boxes and send it over to them and flood them with information. Well, that's no longer a reasonable thing to do, especially in our electronic age, and you are doing just that. You're providing good fishing for the opposing counsel if you were to do something as irresponsible as that. Ensuring that the information truly is relevant and reasonable, and also making sure that if you are going to declare something as part of a safe harbor, that that those conditions are in good faith and in your normal course of business. Another thing is ensuring that the electronically stored information that may turn up to be lost, that good faith operation of your system will not be penalized as a result of those things. Also, it's very important to make sure that you have all the T's crossed, all the I's dotted in your information governance program. So, early preparation is the key. Ensuring that you have a retention schedule, that you're following that retention schedule, that you're routinely disposing of information, and that that is closely integrated with your legal hold system, and that all policy changes are being accommodated, and those policies and procedures and modifications are being tested on a regular basis. Must ensure that they are being proactively enforced and carried out on a routine basis. We're now going to talk a little bit about what does it mean to have a defensible deletion program in your organization and what's the value it brings to the organization. So defensible deletion, many of us have heard about that, whether you're a lawyer, whether you're IT, whether you're records management. So what are we really talking about here? We're talking about ensuring that the information that we're responsible for holding and collecting as evidence to ongoing litigation or audit is being done. It's about ensuring that information we're supposed to be preserving and protecting that is of value to the organization. We're doing that. And when we're no longer required to keep it, we're routinely disposing of, and we're doing this responsibly with a records retention and disposition program. The other part of the equation is all the information that is extraneous to the organization, not official business records, information beyond its retention period, information that may be a duplicate. Defensible deletion is all about cleaning that stuff up. Let's get that stuff off of our repositories, out of our organization, so we're not going through it each and every time. The cost of litigation have been so high in the recent past, it's because they're constantly going through this information over and over and over again. We need to remember that the longer we keep information, the value of it goes down over time. But the risk is constantly going up. So we need to make sure that this information that we don't need to keep any longer is routinely getting disposed of, and that information that we are incumbent to keep, we are keeping that and only that information. So what does a scenario like this look like? So from a functional flow perspective, you have all kinds of different haystacks in your organization, and people are trying to find the needles in those haystacks, and you have silos of information spread across the organization. This information that is important to the organization, we need to capture it. We need to get it out of people's desktops and laptops and file shares and PST files and put it into a secure repository where we can apply formal retention to it and routinely dispose of that information in accordance with our retention schedule and be able to find that information when it's incumbent upon us to do so for eDiscovery or audit. Lastly, we want to routinely get rid of that information that we don't need to keep any longer. And how we're doing all this is we're routinely going out, or possibly a one-time effort. If your processes and policies are strong enough to support it, you can get by with it one time. You're going out and you're crawling these repositories, indexing the information in it, analyzing that information to determine what do we need to keep, what don't we need to keep, and then being able to search upon that result and generate routine reports from those repositories and make some responsible decisions. Take the action. Once again, do I need to capture it, preserve it, and protect it, apply retention rules for future discovery, or may I dispose of it outright? That's the key to the whole thing.
Okay, so now that I have the floor, I have to kind of point out one of the questions that, or comments that has been posted here. It says, a person wrote, "Great, so large corporations get to hide and destroy as much damaging information as they want, so long as no one is dumb enough to admit it." I don't know that I necessarily agree with that assessment. What Tom was pointing out to in that slide number 31 is that you have to establish a routine good faith business practice, and the emphasis there is on good faith. So I don't know that corporations are necessarily out there trying to hide stuff and purposefully try to destroy stuff. I think it's more an issue of there is so much data. You're talking petabytes, terabytes of information that these companies are having to grapple with, that it's hard to figure out what's relevant and what's not. And what we're trying to do here is establish a program that's transparent and that the courts can scrutinize in the way you've been conducting your routine good faith business practices. Yes, you've been disposing of what's e-trash. I don't think that you necessarily know that you're disposing of bad stuff until you know that the litigation is pending or anticipated. Now, at that point, your legal holds kick into place. So prior to that, you've got your routine good faith business practices, but once the legal holds kick into place, anything that exists within your system is still needs subject to a preservation if it's relevant to the subject matter of that lawsuit. So it's a two-step process. It's not necessarily something where people are just going to be using it to bury their skeletons. One thing to add is that when I've done presentations in the past with judges, federal judges and state judges, these discovery wars are the bane of their existence, and the judges are saying, why in the heck are people keeping all this crap around where it's needless? One judge, and I think it was Judge Hedges, said, I remember one weekend I spent the entire weekend reviewing boxes and boxes of data that were provided that were supposedly going to be discoverable, and at the end of the entire weekend that I spent here, I did not find one single document that was going to be discoverable or subject to discovery. So that is something that's worth considering. Another thing that I wanted to add is going back to this previous slide over here, where Judge Scheindling is predicting what reasonable steps to preserve will result in litigation. This is where I'm saying there's going to be a lot more focus on your information governance practices. So if RIM had a seat at the table before, now RIM is going to be at the epicenter because your processes are going to be more scrutinized more closely than ever, as I mentioned earlier. And by the way, I did find the quote. It's by Judge U.S. Magistrate Ron Hedges, and he wrote it in a white paper for ARMA called The Information Governance Maturity Model, a Foundation for Responding to Litigation. And he said, quote, substandard levels of performance invoke the specter of findings of gross negligence or negligence in litigation. So as organizations engage in a cost-benefit analysis to decide which level is appropriate under the principles, generally accepted record-keeping principles, only levels 3 and 4 are sufficient to manage both compliance and business needs. So there you go. You've got it directly from the horse's mouth, an actual judge that is kind of giving the blessing to the generally accepted record-keeping principles. So speaking of record-keeping principles, now focusing on what do you do to prepare for your eDiscovery once litigation is pending. That's where you need to have developed your data map with all your information systems repositories. I had an attendant at a similar conference to this ask me where the data maps, where there's a template for a defensible data map. And unfortunately, those are hard to come by because they're usually proprietary to each organization. And many organizations, it's to create an organization that's in 120 countries with 200,000 employees. It's very hard to come up with a very detailed data map. So what I recommend is that you have a data map of at least your major systems so that you can proceed from there. Identify the locations where the relevant information may be and take immediate steps to preserve the information. So I don't know if you heard it, but the Secret Service is in the hot seat today because they failed to preserve some tapes of a break-in, an attempted break-in at the White House. So the tapes were supposed to be preserved when the event occurred, and yet they didn't have the fortitude or the ability to foresee that they needed to preserve those tapes. They had a 3-day retention for those tapes, and now they're in hot water, and Congress is asking, how could you, Secret Service, not be retaining these tapes when according to your own policy, you said that if there's a significant event, and obviously somebody trying to break into the White House is a significant event, how could it be that you disposed of these tapes? So this is the kind of thing where you can't just simply go around and willy-nilly be destroying things, because that's when the courts then begin to find intent in your destruction of the information. In terms of what you're going to need when you go to meet and confer, this is all stuff that's from previous presentations that we've done before. You need to know about what type and format your data is going to be contained within your systems. You need to have really searched your employees' laptops, desktops, file shares, SharePoint servers, etc. You need to be able to document to the court what steps you took to preserve your information. So again, one of the themes here is that this is once you're in the legal hold mode, in addition to your information governance. So legal hold is part of the bigger picture of information governance. You need to address your cost-shifting arrangements, records management policies, including any exception processing that took place, the format in which the information is going to be produced, and hold on, my slide advanced on its own, preservations of the privilege, and of course any safe harbor clawback examples for things that you inadvertently destroyed. Tom, I'll turn it over to you.
Sure. So as we hopefully have made clear today, your records retention schedule is taking on a much more significant role as a result of these modifications to Federal Rules of Civil Procedure. We hope that we've made that abundantly clear today. That's been one of our key objectives. Also, the importance of the litigation holds and ensuring that they're crafted appropriately and that they, satisfy the intent of the preservation notice and ensure that there's no prejudice with regard to the requesting party. Also, setting up some uniform standards with regard to spoliation, as John mentioned. That's been an important part with these rule changes that are about to take effect. And with that, let's go forward.
Sure. So as we mentioned earlier, the last key here is going to be the focus on intent, which goes back to the comment that was made earlier. And so Judge Scheindlin is concerned that the new rule only allows an adverse inference, which is sort of that presumption that you give to the jury that you're allowed to assume that the documents would have been harmful to you because they're not there. She's concerned that this adverse inference is only going to be given if there was intent to deprive the other party of the information's use in litigation. That being said, that intent is necessary for that very draconian instruction, but don't forget that there are other provisions in there that do allow for the court to consider, if it was negligent, whether or not there was prejudice to the other side, and allow the court to give a sanction that's proportionate to the prejudice that's to the other side. So a sanction could be your inability to, say, introduce an email because it's not in the proper context because you didn't have related documentation related to it. And so the court could say you're sanctioned by not being allowed to present that information and evidence. I want to take this opportunity to answer a couple of questions that came up, and one of them is whether or not the state jurisdictions will follow the new rules. And as a general rule, states do tend to follow the federal requirements. I would say that easily 35 of the 50 states will wind up adopting a pretty much almost like a verbatim version of it, probably within the next year after it comes out. And then about 15 or so states will probably maybe try to tweak it a little bit. Jurisdictions like California and maybe New York and maybe Texas will try to tweak it a little bit to suit their needs a little bit. So I anticipate that's what's going to go on there. Okay, next slide. So the bottom line is, what's the impact of these changes? The biggest impact will occur in how the courts issue sanctions, cost shifting as it relates to monetary fines, special jury instructions, and so as I mentioned earlier, if the court doesn't find intent, it can also then, if it finds prejudice to another party from the loss of the information, order measures that are no greater than necessary to cure the prejudice. We don't know exactly what that will look like or what that will turn out to be. And so that answers the question of how the courts will distinguish between loss in spite of routine good faith efforts versus malicious intent. I think that intent is really something that requires as I mentioned earlier, a mens rea, which means it's no different than when you're prosecuting a case for murder. Did the person commit manslaughter, which is like it was done by accident, or was there an intent, so a planning? So intent is going to be focused on whether you're actually planning. Are they going to find some email? So, for example, the Rambis cases years ago that came down where the witnesses testified that they were going to be battle ready and that they were creating a list of all the defendants that they were going to be trying to protect against when they were destroying the information as part of their sort of discovery preparedness program. So that is the kind of way that the courts are going to be making the distinction as to what's considered intent. So discovery overall is going to be more limited. And there's going to be a stronger framework for litigants to navigate preservation obligations. You're going to have very clear parameters on what's considered proportional, and you're also going to have very clear parameters on what types of punishments the courts are going to be using, because many parties agree and drafters of these proposed revisions agree that the sanctions have been really getting out of control, and they're trying to rein that in. So that's it. We're looking for someone who's capable of seeing the big picture. Get it? All right. So here's our contact information. Let's see. There's another question here. Is the revised 26B1 proportionality analysis limited to costs and expenses? Or does it require looking at Rule 1? I would say that, yeah, absolutely. I think Rule 1 will be overarching many of these things because it is a very closely related cousin or brother of the proportionality issue. So that's just my take on it. Who knows how the courts are going to interpret it. Next question. How are the individual employees' smartphones and tablets pulled within these rules when using their private Gmail accounts? Oh, yeah. Is a party expected to subpoena the employee's Gmail accounts? It is very common for employees. Yes, in fact, I've been taking interviews from the media on Hillary Clinton's and email fiasco with her personal email accounts, and you're hitting upon a very interesting issue, which is the personal email should be just personal, but then this goes back to your information governance and having a BYOD policy that says you're not to conduct business in your personal email accounts, period. Now, that may sound a little draconian, but look, if you're an employee and you don't want your stuff to be searched and subject to discovery, don't transact business through your personal email or through any of your, now, if you've been provisioned by bringing your own device and they've given you access to work account through your personal device, that's different than if you're using your personal email accounts. If you're using your personal email accounts, they are indeed subject to discovery, and also at least in Arizona and Oregon, subject to the Public Records Act. If you're a public official, there's a case in Washington that basically where the court subpoenaed an email was sent to a city councilwoman's personal email account, okay? And She then took that email and read a portion of that email out loud at a city council meeting, okay? The court ruled that by virtue of her reading that personal email at a city council meeting meant that that email was subject to the Public Records Act, and therefore all the metadata and all that stuff associated had to be produced. So it's the City of Shoreline case, if you're interested in it. So yes, bottom line, those emails and your Gmails and all that stuff that's personal could be subject to discovery. So be very mindful of your BYOD policies and be very mindful of for auditing and making sure that if you know that people are systematically using their personal email accounts for business, that those are included within your discovery net in the event of pending or anticipated litigation, unfortunately. I think that's it. I'm going to turn it over to Robin right now, unless, Tom, you have anything else to add?
No, you've been very thorough, John. I think we're good. Let's see what we got from the audience.
We've got a few more questions left. We're hearing a lot about governance, and it's certainly one of the topics that we've been asked to give more education on. Folks would like to know, how can they get their executive team on board to create a governance program within their organization?
Tom, I'll let you take that one.
Sure. So as somebody who's routinely asked this question, sometimes, you know, it's regrettable. You can be the voice of reason in the wilderness, and they don't recognize you because a prophet in their own town, in their own time, is never recognized. So you may find that you need to bring in somebody from the outside, or they need to attend a webinar like today to understand the importance of it and why they need to make an investment and make this a priority in their organization. Or you need to, as I indicated earlier with that one colleague in the Houston area, find the master change agent in your organization and latch your strings to that person.
Excellent. John, I'm going to pose this one to you. Do you recommend an information governance committee, and who should be on it?
Yeah, I definitely recommend a steering committee. I mean, you're going to information governance one-on-one. You'd need to start by creating, well, first of all, having somebody at the senior leadership that's going to sponsor an information governance program. And now there's actually advocacy for actually creating an information governance officer that oversees this. Now, once you've got your information governance officer, you really should have what I've heard you, Robin, refer to as the 6 communities of practice. So you really should have somebody from IT there, somebody that deals with privacy, risk, compliance, records management, and legal. Those are must attendees in there. And then depending on the organization that you've got, maybe maybe somebody from HR is going to be really critical on there to really be assessing the change management aspect of information governance and how they would affect the employees, and maybe some other critical vertical lines of business within your organization need to be invited. But at minimum, those 6 communities of practice should be there.
One other one, John, that I'd add to that list, it's very important to make sure you have a representative from the Chief Financial Officer's office in those meetings. Because at the end of the day, it comes down to prioritization and understanding and listening to the debate go on between compliance and legal and information governance is going to be very important.
I think that is a brilliant observation to bring in the folks who are going to have to fund the initiative. We're coming up to the top of the hour, and I wanted to give a couple of reminders. We were fortunate enough to have Diane Carlisle listening to our webinar today, who is an executive director of ARMA International. She wanted me to remind you that the 7 Steps of Legal Hold is available through the ARMA bookstore. A lot of good references on things, as John and Tom have said today. Next month, our webinar will be on April the 16th, and the topic is Stop the Leaks, Exiting Employee Strategies, Ensuring You're in Compliance Even When Employees Have Left, featuring Adam Feinberg and Barry Schwartz. I would like to thank everyone who tuned in today to hear our program, and I would specifically like to thank our guest speakers today for taking part in this educational series. Thank you, John, and thank you, Tom.
Thank you,
Yeah,
Robin.
and if you want to email me directly, you can either email Robin or you can email me directly at, just to make it simple, john.isaza at, there we go. There's the email. I didn't see that slide. I couldn't find it. So that's our contact information if you need us.
And as I indicated earlier, we'll be sending out certificates of attendance to those of you attended. And once again, thank you and wishing you a fabulous